Well, good morning, everyone, and thank you very much for attending our panel discussion this morning with the possibly somewhat thorny title of Brexit, What You Need to Know. My name's Jo Rhodes. I am a senior associate in the firm's commercial litigation team, and I'm also one of the co-chairs of ThinkHouse Foundations. Just to say a little bit about that, ThinkHouse Foundations is the partner programme of our main ThinkHouse series. While that one's aimed at more senior in-house lawyers all the way up to GC level, Foundations is aimed at the more junior end, from trainee solicitors all the way up to kind of 5 or 6 PQE. And we really try to focus in Foundations on giving more kind of practical assistance with the things that might come across your desk from day to day. I'm told that we started with one talk with about 10 people in attendance. So looking at numbers today, it's come a little way since then. I have the pleasure of chairing, or perhaps refereeing, this discussion today, which is the second in a series of 3 ThinkHouse Foundations webinars for the spring-summer season. On Tuesday just gone, Sam Cooper from our Planning and Environment team kicked off the spring programme on the topic of a new era for environmental law. If you weren't able to make that one, don't worry, because we do record all of these sessions and I would definitely recommend giving it a watch. There's lots of practical tips in there. The final talk for this programme will be a contract law update, which is going to be on the 8th of June, and will be given by Sarah Townsend, who is one of my colleagues in the commercial litigation team. And that should be a really helpful overview of just some of the key developments in the area over the last few months or so. I think the final thing for me to say before I introduce our speakers is that there'll be a link circulated both during and after the webinar to complete a short feedback questionnaire, and I promise you it is very short. So if you do have a moment, we'd really appreciate any thoughts you have on today's session, and also anything you'd like us to cover in the future. I can't really emphasize how important your feedback is in helping us to shape future programs, telling us what you want to hear about. So please do take a moment to complete it if you can. So moving on to today's talk then. I'm very pleased to be joined today by several of my colleagues from across the firm's specialties, and I'd like to take a moment to introduce them. First, I have with me James Stunt, who is an associate in our EU trade and competition team, who specialises in international trade issues and customs compliance. So obviously very important that he's with us today. I have Kami Salan, an associate from our intellectual property team who specialises in brands and designs. I have James Hall, who is an associate from our employment, labour and equalities team who specialises in employment law. James is also my co-chair for ThinkHouse Foundations, so he was going to be part of this panel whether he liked it or not. I have Alex Kim, a senior associate from our commercial IT and outsourcing team, who specialises in data protection. And last but certainly not least, I have James Barr, a principal associate in our commercial IT and outsourcing team. James specialises in international outsourcing agreements and contracts for the supply of goods and services, with a particular focus on the automotive and aviation sectors. As for the structure for today, we're going to start with our panel discussion and then move on to an open Q&A session. And you'll see, I'm just checking they've all done it. Yeah, you'll see that our panel have put their specialities in their names on Zoom to help you direct any specific queries. We have activated the Q&A function on Zoom, so please feel free to ask your questions there. And just to say that only the panelists and myself will be able to see those. We'll try to answer as many as we can in the time allowed, but if we don't get to everyone's, we will follow up after the session. And equally, if there's anything very specific or specific queries you'd like advice on, our panel will obviously be very happy to follow up afterwards. Finally, on the Q&As, if you're asking a specific question for one of the 3 Jameses, if you could specify which one you mean, that would be enormously helpful. And equally, of course, if you want to ask a question to the panel at large, that's also very welcome. So I think that's enough out of me, and it's time to hear from our panelists. And kicking off the discussion, I suppose a good place to start might be to ask you all, so we're kind of four and a half months, I suppose, down the track now. What do you think is, or perhaps are, the most important things for people to be aware of in your practice area post-Brexit? Or perhaps what are you seeing most queries coming across your desk about? And as our resident EU lawyer, I think I'll come to you, James S. first, if I may.
Yes, thanks very much, Jo, and good morning, everybody. So yes, from our perspective in the EU trade team, Brexit has, of course, significantly altered the UK's trading landscape, and it's raised new challenges for many businesses, but in particular for those businesses which are involved in cross-border trade with the EU. So as I'm sure most of the audience are aware, the UK was previously a member of the EU Single Market and Customs Union. And as such, it was able to benefit from common customs rules that applied across the EU and zero tariffs on goods which were traded between EU member states. Now, of course, the UK's relationship with the EU has changed. It's now governed by the Trade and Cooperation Agreement, which myself and some of the other panelists will be referring to as the TCA throughout this webinar. What this deal effectively does is provide for tariff-free and quota-free trade between the UK and the EU, which in practice means that goods can move across the border between the UK and the EU without attracting any additional import duties. So broadly, this is beneficial for UK businesses, but it has meant that cross-border trade with the EU has become a lot more complicated post-Brexit, and in particular for those UK businesses which have traditionally or typically engaged solely in EU trade. And obviously this is for a number of reasons, but I thought it'd be helpful to highlight some of the key areas that are useful to keep in mind. So the first of this would be the new border controls and customs formalities, which now apply for goods moving between the EU and the UK. So following the expiry of the transition period on the 31st December 2020, goods which are brought into the UK from the EU and vice versa are now treated as imports, and so will be subject to border controls in the same way as imports from countries from the rest of the world. What this means is that there are now requirements for you to make customs declarations, as well as paying any applicable import duties once your products are imported into either the UK or the EU. And additionally, if you're importing certain types of products, say for example, products of animal origin or animal byproducts, you might be required to undergo additional processing for these goods, such as pre-notifying HMRC or obtaining an export health certificate. Helpfully for the UK, for businesses which import into the UK government has adopted a phased approach to implementing full controls at the border. And this is set out within the UK government's border operating model, which is a compendium of information about the key deadlines for the transition to full border controls, and also gives details about the specific procedures required for certain goods. The key point, I think, out of the border operating model at the moment is that it's possible to delay making customs declarations and paying import duty for up to 6 months from the date on which your goods enter the UK. And under the current model, that applies until January 2022. Although it's possible it might be pushed out. We've already seen the UK government pushing the deadlines for full border controls out. It's also quite important to keep in mind that this phased approach only applies in respect of moving goods from the EU to Great Britain. So if you're importing goods into the EU, you need to make a customs declaration, a full customs declaration in the usual way. A second point just to flag is that trade and services has changed significantly. So the pre-Brexit situation was that service providers could benefit from the EU single market and the EU principles of freedom of movement. So services could be provided and received freely between the EU member states, which begs the question, where are we now? The TCA does include provisions which aim to liberalise the trade and services between the UK and the EU, but it's not quite fully liberalised. There are still various restrictions that apply, particularly for individuals who are travelling temporarily to the EU or to the UK for business purposes. And these restrictions include restrictions on the activities that certain types of service providers can undertake, There might also be additional requirements, such as establishment requirements or concerns as to the contractual terms of the service contract. And additionally, there are member state specific requirements for where the services are being provided, such as economic needs tests. So all of this means that it's more important now than ever for businesses operating in the cross-border supply of services to make sure that they check the requirements that apply for the individual categories of the service in which they operate, as well as the types of activities that their service providers undertake. And just a final point, it's been in the news quite a lot, but Brexit has raised new challenges for businesses operating in trade involving Northern Ireland. A key aspect of this is governed by the Northern Ireland Protocol, which provides that the Northern Ireland remains part of the UK's customs territory. So when the UK enters into a free trade agreement with another country, Northern Ireland is accounted for in the scope of such an agreement. But crucially, the customs rules of the EU continue to apply in respect of Northern Ireland, and Northern Ireland remains part of the EU's regulatory regime in certain regards. So what this means in practice, in brief summary, is that if you're moving goods through or to Northern Ireland, there may be additional considerations that apply. So, for example, if you're moving certain qualifying goods into Great Britain from Northern Ireland, you won't need to undertake any additional customs procedures, such as export declarations or paying customs duties. But if your goods start their journey in the EU, then they must comply with customs and export requirements on entering Great Britain. You can't use Northern Ireland to circumvent the UK tariff and import processes, and you might actually be subject to penalties if you do so. So that's a very high level overview of some of the things we've been seeing in our practice area. So I'll just hand back to Jo on that one.
Thanks, James. And I'm sure you could probably take up this entire time slot with just talking about that question. So thanks for keeping that as brief as you could. I suppose probably no one will be surprised to hear that there's a fair bit to bear in mind in your practice area. And I certainly don't think anyone's going to be surprised to hear that trade is not quite as straightforward, perhaps, as it used to be. James B, could I come to you next? James has touched on obviously trade there, which is obviously fundamental, and I can only imagine is front and centre in the thoughts of any business which trades with the EU. I suppose I'd be interested to hear, how can you manage that on a commercial level? I mean, what's important for those businesses to be aware of post-Brexit on a kind of contractual or commercial basis?
Yeah, so I mean, that's a good question. So I think certainly what we've found from a commercial contracting perspective, I mean, not a lot has changed. There's obviously a huge amount of things to consider with cross-border contracts, but a lot of these are around the trade and how you actually get goods across the border. In terms of how you draft your contracts, as I say, not a huge amount has changed, and that's mainly because we've implemented much of the EU law into retained EU law into UK domestic legislation. So the law as it stands remains broadly the same. I guess there's probably two key legal things, two key legal issues to think about, and that we are getting questions around. One is I guess regulatory. So the regulations in the EU and the UK are starting to diverge, I guess. So labelling, packaging requirements, for example, would be an obvious one. Registration, licensing arrangements with the relevant local authorities, that has become more complicated as well. But I guess from a purely what to consider in your contract, the key thing would be law and jurisdiction. That's probably the biggest impact and things to think about. And that's because the cooperation agreement really hasn't dealt with disputes. It's effectively a no-deal Brexit, and we've lost many of the sort of the benefits, the cooperation benefits, as a member of the EU. So there's probably it's probably worth just sort of touching on two of two or three of the key areas. So the governing law, the choice of forum, and the enforceability of contracts, and how pre and post Brexit that's changed, I guess. So sort of taking the first point, governing law. So obviously this is about what's the choice of law that governs your contract. Pre-Brexit, that was in the EU, that was governed by the Rome Instruments. And the basic position was that member states recognise the parties' express choice of governing law. And there's various rules that then determine, in the absence of an express choice, what the law that applies. The good news is that post-Brexit, the UK has transposed the Rome rules into domestic legislation. So for now, there's no change. The EU member states will recognise UK law and vice versa. The one thing to watch out for on that, of course, is that the UK is not bound to mirror changes to the EU Rome legislation, so or follow the ECJ. So we could find that we start to diverge away from them, and then things may change. But for now, there's no change, and no drafting is changed. No change in approach to how you draft your contract. Where it gets more complicated, I guess, is the choice of forum. So the jurisdiction, who gets to hear your dispute, and the reason why this is important is because the local legislation, the national law, the rules and procedures just vary and may affect the case, the dispute. So pre-Brexit, we benefited from, as a member of the EU, we benefited from the Brussels-Lugano regime. And so this, again, a little bit like the governing law arrangements, this set out a set of rules to determine which country has jurisdiction. And the basic position is that the EU respected the party's choice of court. Post-Brexit, it's slightly difficult. They're slightly different. So whilst there are some transitional rules around the disputes that commence pre-1st of January 2021, the UK is we no longer have the benefit of the Brussels-Lugano regime. So we were applying to join the Lugano regime, but that is still being debated and basically being blocked by the EU at the moment. I think that's partly due to, the EU wanting to take contracts away from English law. So they're thinking that the governing law will start to become an EU law rather than English law. Whether that's the case, I don't know. I'm not sure we're seeing a huge amount of that anyway. But at the moment, as it stands, we don't benefit from the Lugano regime unless we get accepted as a member. So as it stands, the choice of forum would be governed by a different set of legislation, which is the Hague Convention. But the key problem with the Hague Convention, there's still three main issues. The first one is it doesn't apply to certain disputes. So intellectual property, employment, consumer claims, it doesn't apply to that. The second one, it only applies to exclusive jurisdiction clauses. So it doesn't apply to non-exclusive jurisdiction clauses. And there is some uncertainty as to whether or not the EU will respect pre-Brexit exclusive jurisdiction clauses, because the UK only acceded to the Hague Convention in its own right from 2021. So there's this sort of gap between 2015, I think it is, and 2021 as to it's not clear whether the Hague Convention would apply either. And the final point is the Hague Convention is not tested. So if the Hague Convention applies, then broadly speaking, the EU member states would recognise the choice of law. But there is a lot of uncertainty as to whether it does apply. And if it doesn't apply, then it falls to national courts applying national laws. So the practical implications of that are that there's just a lot of uncertainty, and there's going to be a lot more increase in local legal advice required, and obviously the added costs of that in disputing contracts and enforcing those contracts. So enforcement-wise, again, the enforcement of those contracts, even when you get judgment, you've got to go and enforce it in the local jurisdiction, and that again is governed by the Brussels-Lugano, or was pre-Brexit. Post-Brexit, it's the Hague Convention, which has the same issues that we've just talked about. So yeah, there's a lot of uncertainty, and it's likely to be more costly. But I think it's probably worth bearing in mind that we probably don't want to overstate the risk. It's not that the contracts aren't enforceable. It's just going to be slightly less certain as to how you do it, and as I say, increase the cost in doing it. In terms of the sort of, I suppose, practical points about how you can mitigate this, then making sure your contracts have exclusive jurisdiction clauses going forward, or you choose arbitration. So Brexit hasn't affected the arbitration process. That is governed by the New York Convention, and we're still a member of the New York Convention, so arbitration would apply in the same way.
Thanks, James. And as a commercial litigator, I'd certainly echo a lot of what you've said about jurisdiction, and particularly the difficulty of enforcing judgments, because it does add that extra layer of complexity. I don't think disputes are anything anyone really wants to think about when they're entering into their commercial contracts, but if you can, make it as good as you can at the time, that certainly can make your life a hell of a lot easier if something does go wrong later down the track, which unfortunately sometimes it does. So we've talked about what we need to be aware of in terms of tangible goods and services, and how we might need to think about drafting our contracts to get around some of the, I suppose, the novel points which Brexit presents. But we also know that we also need to bear in mind the kind of the intangible, all-important IP, Amy. So what about that? What do businesses need to be aware of, or what are you seeing most of coming across your desk in the kind of IP realm?
Thanks, Jo, and good morning, everyone. I think it's most important for businesses to understand how Brexit has changed their intellectual property rights. So intellectual property is a broad term that covers different intangible assets, and there are different legal regimes covering each of the different types of rights. For the purposes of this conversation, I'm going to focus on trademarks because I think it applies most broadly to everybody who's listening, because every business has a brand. But there have been changes to the regimes around patents, copyrights, and designs in particular. So if anybody has specific queries about that, please do drop me an email. So looking at trademarks specifically, trademarks are designed to act as an indication of the origin of goods or services offered by a particular business. They're registered rights that record things like your brand name, logos, slogans, and occasionally more unusual things like colours or shapes and sounds. So if you take a brand like Nike, they will have a registration for the name Nike as a word mark. They'll have a registration for the swoosh logo, and they'll have a registration for the slogan "Just Do It." And when you hear or see any of those icons, they indicate to you that the goods have originated from Nike. This mark is then registered in relation to specific goods and services. So they'll be registered in respect of apparel, footwear, and maybe even services such as sponsorship, or in providing stadiums and things like that. So prior to Brexit, a business or an individual could apply for a trademark that covered all of the EU. And the benefit of this was that you made one application to a single office, you paid one fee, and you had one renewal fee, and you had protection across all of the member states of the EU. However, post-Brexit, the UK obviously no longer forms part of the EU, and there is no longer covered by the EU trademark regime. So for those businesses that had EU trademark registrations prior to Brexit, they will now have two trademarks. They will have their existing EU registration, which no longer covers the UK, and they will have a UK clone of that registration. It'll cover exactly the same mark, it'll cover exactly the same goods and services, and it'll have exactly the same priority date. It may be that some businesses already had an existing UK registration, so they may now have two UK registrations covering different goods and services. So for businesses who have two registrations in the UK, they need to consider whether it's necessary to maintain both, because it can be expensive. And for businesses who are looking to register trademarks in the future, they need to consider where they should be applying for protection, what rights they're using in the territories, and what goods and services they need to cover in those territories. I think it's really important to note that there isn't a transition period for trademark registrations. So on 1st of January this year, the UK clones of those any existing EU trademarks were automatically created. And so if your business already had an EU registration, you now will automatically just have this UK right. However, if you'd filed an application and the application hadn't been processed prior to Brexit, you will now need to make a UK application prior to the end of September to make sure that you've got corresponding UK protection for what will be covered by the EU right. just taking all of that into consideration, I think it's really important for businesses to take stock of all of the different rights that they own and that they are using, and just to check that these are all working for the business and that the new rights cover what the activity that the business is undertaking in the relevant territory.
Okay, thanks, Kami. It seems to me there's a little bit to be thinking about there in terms of the kind of IP side of life. James H, can I come to you next? We've talked about goods and services and IP, but what about what's arguably a business's most important asset? Has there been a lot of change in the employment sphere since Brexit as well?
Morning, Joe. Thanks. I'm afraid my answer is a little bit different to everyone else's so far. It's effectively to say, or maybe similar to a lot of what James B's already said, but there hasn't really been any impact as such from Brexit immediately to employment law. So there's been no change to what I'm sort of advising on day to day, as a result of Brexit. But I would focus on maybe the other part of your question, which is what are the most important things to be aware of now that we're post-Brexit? And I think James B's already touched on this idea of the retained EU law. So hopefully it's a familiar concept that we've now effected as of the 1st of January. We've got this snapshot of EU law in the UK, especially in the employment side of things, and what that means is that it's as it was before, but as things might start to change in the future, we could certainly see some divergence, and I'm sure we'll be talking about that later on a bit more detail. But thinking about what's important to be aware of, I thought it might be helpful just to run through some of the sort of parts of our UK employment law that's actually come from the EU. And some key examples of that would be things like discrimination rights, collective consultation rights in a redundancy scenario, TUPE, or the transfer of undertaking regulations, which hopefully is something that we've all come across before, things like family leave, working time limits, things like the 48-hour limit on a working week, and also agency workers' duties. So those are all things that have come from the EU, and who knows, whether they'll, continue in the same way. So, as I said, we can talk about that a bit more later, maybe. But I thought it was also worth flagging that some things that have come from the EU were already here in the UK, and that would include equal pay rights, race and disability discrimination laws specifically, and also things like the right to return from maternity leave. So, as James S has already mentioned, it's this TCA agreement that we're really interested in, and there's even some specific wording in that says, there's provisions for the development of employment rights in both the UK and the EU going forward. And there's hopefully we've all heard in the media this reference to the level playing field commitments. So that's designed to prevent either side from getting a competitive advantage over the other, and that does include labour and social standards. There are some rights to modify, but effectively there's a commitment not to weaken or reduce labour and social standards. But crucially, that's limited to being in a manner which is affecting trade or investment. And right now, we don't really know quite how that's going to be dealt with or interpreted going forward. So those are the key things I'd say good to be aware of post-Brexit employment.
Okay, thanks, James. So sounds like there's not currently too much for businesses to be too worried about, which I'm sure will be welcome news to our audience. Alex, can I come to you on that note? I mean, it always seems to me, as someone who is not a specialist in the area, that data protection is something that we all need to be constantly worried about all the time. But what would you say are the kind of main points for people to be aware of post-Brexit in your practice area?
Yeah, thanks, Joe. From a data protection perspective, we haven't seen a drastic change in the law either as a result of Brexit. The data protection laws that now apply in the UK are the Data Protection Act 2018 and the UK GDPR, which are pretty much the same as the law pre-Brexit. Of course, these laws may change in a way that deviates from the EU GDPR going forward. The most frequent question that we are coming across is what has happened to international transfer of data, specifically in relation to the EU, or I should say European Economic Area to be more precise. So as a starting point, with Brexit, that means international transfers of data from the UK to other countries, including to the EEA, are now subject to transfer rules under the UK GDPR. Now, these rules are largely the same as they were before Brexit. For transfers of data from the UK to the EEA, the UK government has recognised the EEA as being adequate, and so no specific documentation such as standard contractual clauses is required to transfer data from the UK to the EEA. For transfers of data from the EEA to the UK, the EU GDPR applies. And as things currently stand, the UK government is seeking a European Commission adequacy decision, which will allow the free flow of data under the EU GDPR. And to allow time for the EU to consider whether to grant this adequacy decision to the UK, the EU has agreed to delay transfer restrictions for at least 4 months, known as a bridge, at the beginning of this year, and this may be extended to 6 months. And so far, things are looking fairly positive. In February this year, the European Commission published its draft decisions on the UK's adequacy, where the Commission found the UK to be adequate. The draft decisions are now being considered by the European Data Protection Board, the EDPB, and a committee of the 27 EU member states. If the committee approves the draft decisions, then the European Commission can formally adopt them as legal adequacy decisions. Now, if the UK were to not get the adequacy decision, then the UK will be treated as a third country under the EU GDPR, meaning that certain appropriate safeguards, such as the use of standard contractual clauses, may need to be put in place. So what we have recommended clients to do in the meantime is identify specific transfers of data between the UK and the EEA so that measures can be carried out promptly if required. And yeah, that's it.
Okay, thanks, Alex. So I think that leads me nicely onto my next question then. We've talked about what's been going on, or in some cases not going on, over the last few months in relation to Brexit. But kind of post-Brexit, and I think some of you have started to touch on this already. What, if any, kind of retrospective changes might need to be made to existing arrangements which are currently in place? So I think, if I may, I will start with our commercial lawyers on this one. James B, what would you say about that? I think we've said that people don't need to be rushing to amend their current contracts, but what would you say?
Yeah, I think that's right. So the short answer is no. We haven't seen a rush of clients and companies wanting to renegotiate and amend, or certainly not wanting to amend their current contracts. And I think that's partly because, as we touched on earlier, that there's not been a great deal of change in the law that applies to their commercial contracts. You know, when we take the issues with jurisdiction clauses, you know, the fact that you've got a non-exclusive jurisdiction clause in your cross-border contract, people aren't going to, you know, companies aren't going to start amending their contracts just to deal with that. I guess where we are seeing clients want to renegotiate their existing contracts is where there has been a commercial implication, and obviously James S has touched on this in terms of the trade and cross-border transactions. So particularly where the contract, where the sort of implications of Brexit, such as delays in crossing the UK border, UK EU border, where that causes a big problem for the contract. So just-in-time deliveries in the automotive sector, for example, you find a lot of clients wanting to look at those contracts. Just the costs in crossing the UK EU border. The increased logistics costs, because we've got more complicated logistics arrangements and the risks of delay, import-export controls as well, the exchange rate risk as well. So again, back to the commercial reality of what's happening with these commercial contracts, to the extent the volatility in the exchange rate is causing a problem in terms of the pricing that you've agreed in your contracts. And I guess the other key area where that's causing a problem is the movement of people. So where you're providing services, if you're providing services at another party's site and it's cross-border, the restrictions on movement of people is going to be a problem as well. And how do you deal with that? So really where we're seeing the renegotiation of contracts is around due to the upward pressure on costs in performing those contracts. So what we'll find is that the clients are looking at higher risk contracts to try and reallocate that risk and the cost of crossing the border. That can be quite difficult. So one of the reasons why you is not necessarily seeing a lot of the contracts being renegotiated is because if you're locked into a long-term agreement and you have no right to amend it, or you've got no price review clauses, then that's quite problematic. You've just got to wait until the end of the term potentially before you can renegotiate that contract. So again, that's another reason why we're not necessarily a rush of activity to amend contracts. What we are finding though is that commercially, there's a few things you can do to mitigate those risks. So, you know, if delay is a big problem, building up stocks of goods where possible, investing in IT systems, experts and consultants to assist with import-export requirements. And I suppose going forward, what we're looking at is in your contracts is dealing with some of these risks. So including price review clauses, having shorter term contracts. So long-term contracts in where the market is quite uncertain may not be a particularly good idea. So looking at shorter term contracts. So really that's the sort of more commercial, practical issues that we're finding clients are asking about and looking to try and address in their existing contracts. And I suppose that the final point just to bear in mind is that these practical commercial implications are not just around cross EU UK border. It also potentially impacts just the UK contracts where those contracts are reliant on the EU supply chain. And of course also Brexit has an impact on UK non-EU cross-border contracts because of potential tariff changes and border delays, increased logistic costs. It's the same issues that arise with those contracts as well.
Thanks, James. I think there's some really helpful kind of practical and commercial tips in there. What about from a data protection perspective, Alex? Is there anything that people need to be thinking about looking over their existing arrangements?
Yes, from a data protection perspective, nothing immediate really comes to mind. We have had to be mindful of drafting the correct definition of data protection law in our contracts now. But however, to go back to contracts already signed to just make that specific change, I don't think that's really a critical matter. I would like to just answer one question from the attendees. The attendee asked, what are the requirements for businesses to have an Article 27 post-Brexit? So that's referring to representatives of controllers or processors not established in the EU. I'll just be really quick. If you are a UK organization selling into the EU market with no presence in the EU market, then you will have to have an EU representative. The same applies for EU organizations. If they are selling into the UK, they're caught by the UK GDPR. And if they don't have any, if they're not established in the UK, then they will need to have a UK representative.
Thanks, Alex. What about from your perspective, James S? I am going to hazard a guess that there are some things perhaps that you would recommend are done from a retrospective point of view, given there is so much to think about. But what kind of things would you be advising that businesses are thinking about at the moment?
Yes, so James B has quite helpfully gone over a lot of the practical contractual changes that can be implemented to take into account quite a lot of the changes which I touched on sort of earlier in the webinar. But one area that we're advising clients on quite a lot recently is origin management, which is essentially involving an evaluation of many aspects of a business practice, so their supply chain, their products, the manufacturing processes. And the reason for doing this is ensuring that businesses have been taking advantage of tariff-free trade in the past and are able to continue doing so now we're in the post-Brexit environment. So just to sort of give a quite high-level summary of that process, I mentioned earlier that the TCA allows for tariff-free trade between the UK and the EU, which in theory is wonderful, but it requires businesses, that businesses can only benefit from that tariff-free trade if their products satisfy what are called rules of origin, which are specific rules set out under the various free trade agreements which the UK has entered into with other countries throughout the world. And obviously that now includes the EU with the TCA. Rules of origin themselves are relatively complex and quite specific. And slightly unhelpfully, they differ depending on which free trade agreement you're looking at. But broadly speaking, businesses can undertake origin management exercises in sort of a 3-stage process. So the first step would be to identify what the correct commodity code is for your individual products, and that's the 10-digit code that applies to all products that you could conceivably think of. The next step is if your products aren't wholly obtained, so if they're not grown in the relevant party to the free trade agreement that you're looking at, or extracted naturally, you need to look into the provisions of the relevant free trade agreement that you're looking into and check whether your products satisfy the product specific rules of origin. And quite often that requires that your products undergo specific changes or processing in order to change their status to originating status. And once you've undertaken that exercise, you have to then claim preferential tariff treatment on your goods at the point of import. And again, the way in which you can do this does differ depending on which trade agreement you're looking at. But for the purposes of the TCA, you can do this by submitting a supplier's statement of origin on your commercial invoices or other commercial documents when you're making your import declaration. If you've also given enough information to the entity that's importing your goods, you can rely upon what's called the importer's knowledge for this purposes. But there are certain practical steps. It doesn't come automatically to you when you move goods across. And we're advising clients do this both on a current and a retrospective level. So if you're failing to make use of a preferential tariff treatment under a free trade agreement, you could potentially be paying hundreds of thousands of pounds worth of import duties, often unnecessarily. And that's particularly the case if you are operating in an industry that's got particularly high tariffs. So the automotive sector, for example, or the clothing sector, textile industry. And what's also quite useful for businesses, and something we've advised on relatively recently, is that if you haven't been using the preferential tariff treatment provisions under previous free trade agreements, you can actually make an application to a customs authority to reclaim certain time limited periods of duties, which can be quite a boon to the businesses. So there are a few steps that businesses can look into from their products manufacturing supply chain perspectives, just to make sure that they're making the most of what's available to them under the new trading arrangements.
Thanks, James. And again, I don't think anyone's going to be surprised to hear that there is quite a bit to be thinking about, but we are, of course, always here to help you if you need it. Amy, you said that there's quite a bit to think about from an IP point of view. But what about people looking into their existing arrangements in that area? Is there anything you'd particularly recommend?
So it's not so much retrospective changes that need to be made as reviewing and considering your existing arrangements and to make sure that they work for you going forward in this new post-Brexit landscape. So I think broadly this can be broken down into two things. Firstly, it's reviewing the brands that you're using, where you're using them, and what rights you have registered to protect that use. And then secondly, looking at what rights have been licensed. So who are those rights licensed to, and do these agreements need to be updated to reflect any changes? So dealing with the first point about reviewing your brands and making sure that they work for you, and what you have registered. I mentioned earlier that trademark owners will now have UK clones of their EU rights, and that some brands may already have pre-existing UK registration, so they've now got the 2 UK marks. And businesses need to consider whether it's necessary to maintain both marks. There may be very good reason for doing so. So the pre-existing mark may have covered a more narrow selection of goods and services, and the subsequent clone may be more broad in scope. Similarly, you may want to retain the newer mark if it's within the first 5 years of its registration, as you don't have to prove that you've used it in relation to all of the goods and services. And this means that it can then help if your mark is attacked for validity. You don't have to prove that it's being used in relation to all of those goods, because after the first 5 years, you do have to prove use. And if you can't, then your mark can be invalidated. On the flip side of that, though, if you've got a very old registration that you've been using for a long time in relation to all of the goods and services, you may want to maintain that mark, because you'll have accrued lots of goodwill and reputation under that brand. And that can be really helpful when it comes to dealing with infringers. So it's just considering whether the registrations that you have now cover all of the goods and services that you are using them for, and what the most cost-effective way of maintaining the rights that need to work for you. And then my other point was about licensing. And so with licensed trademarks, you need to make sure that the licensee has the correct rights to cover their activities and to cover their use. And this is obviously the case regardless of Brexit. But I think it's worth reviewing agreements to see who's covered to use which marks in relation to what goods and services. So, for example, if you're licensed to use an EU trademark, but you carry out your activities in the UK, you may need to consider whether the license is updated to reflect any changes. And we recommend just seeking some advice on that, really.
Okay, thanks. So it sounds like it's actually quite a good time to sort of take stock of what you've got, and what might need to be given a bit of a refresh or not, as the case may be, in terms of your IP. James H, you said that not a lot has immediately changed from an employment perspective, but is there any need for businesses to be thinking about making any retrospective changes?
Yeah, you're right, Joe. No, the answer here is hopefully a positive one, which is there isn't really any need at all. So it's a pretty short answer from me. So yeah, there's nothing that we recommend changing in employment contracts or anything like that. So yeah, I'll defer to my colleagues on this one.
Okay, well, I think that's happy news, to be honest, and I'm sure everyone's very pleased to hear that that's at least one thing they don't need to worry about. At least not immediately. I am going to stick with you though, James, as you've not given me an answer, and you're clearly not being kept busy enough with Brexit related work at the moment. So moving forward then, what would you recommend people perhaps look out for in the future in employment law, or that you think might be coming down tracks?
Okay, well, I've certainly got a bit to say about this. You'll be pleased to hear.
I'm pleased to hear it, James.
So I touched on earlier that the TCA has these level playing field provisions that restrict us from making major changes to existing employment law. But as I said, they don't completely prevent changes taking place, and the non-regression commitment is limited to measures affecting trade or investment only. So I think I was also already said that we're not really clear what that might mean, but we're thinking that minor changes are pretty likely, and so there's not going to be significant gaps opening up between the UK and the EU anytime soon. And as James B already touched on, we're not going to be going to the European Court of Justice for helpful decisions that can then be applied in our low-level employment tribunals and similar courts. So, but having said that, there's been lots of talk in the employment practitioner world about what changes might be coming down the track. So I thought it might be interesting to talk through some of those and some of the, well, certainly some of the key ones, and from my point of view, that are likely to be most interesting for in-house lawyers. So the first one would be discrimination law, which, as I touched on before, is established out of EU law, primarily. And what we might see is a cap being applied to compensation that can be awarded for discrimination claims. So currently it's uncapped, although, there are rules about how you work out the compensation, but there's currently no cap in the same way that there is for unfair dismissal claims, for example. So we might see something like that brought in the future. There's also the chance that there could be changes to the law regarding positive discrimination to favour underrepresented groups in society, which are not currently permissible under EU law. There's also a chance of changes to TUPE, which is a bit like Marmite. You either love it or you hate it, and some businesses find it useful and some don't. And I think hopefully James B would agree that it's usually priced into most commercial agreements where it's applicable. But we think there could be some sort of potentially some business-friendly changes, such as making it easier to harmonise employee terms following a TUPE transfer, which is currently not permitted. And that could be a really big change and make sort of a lot easier to bring different businesses that in line with each other. Another one could be holiday pay, which is a really can be a very, very expensive issue for businesses who have come across that, where there's been lots of recent EU high-level EU cases which have effectively said that people should be paid their normal pay during holiday. Which, as you might imagine, can be quite tricky to work out sometimes. And then this is obviously redundancies. There's a lot of redundancies going on at the moment, unfortunately, given where we are with the pandemic and current state of the economy. So there are rules, as you may know, about sort of when you're dismissing more than 100 employees at once, about the length of time to consult, things like that. So we may see changes to that in the future. And then finally, although I'm not an immigration specialist, I think it would be silly not to mention that, now that we've got this new immigration points-based system, so that's something to be thinking about in terms of EU and non-EU citizens who come to the EU and how they'll be treated in the same way going forward in terms of, movement and right to work and things like that.
So it sounds like the message from your point of view is watch this space.
Exactly.
See what happens. Yeah, okay. Thank you. James B, can I come to you next? So from a kind of purely commercial point of view, we've heard a lot about the threat, or in some cases, the reality of some UK companies moving their main operations to the EU. Have you seen anything come up about the kind of the structuring of businesses more generally in a post-Brexit world, I suppose, or anything that might indicate what's coming down the tracks in that regard?
Yes, I mean, I'm not sure necessarily everybody's rushing to move head offices around the EU, but certainly there is a lot of restructuring and of businesses and supply chains to deal with Brexit. So, I mean, essentially what we're finding is that companies are splitting their supply chain to avoid crossing the border. So, setting up warehouses and logistics arrangements in the EU and separate arrangements for the UK. And obviously with that comes additional costs. I guess the other thing we're seeing is setting up of EU group companies and vice versa in the UK to deal with local registration, licensing arrangements, for example. So because the regulatory framework might be different, and you might need a local entity to register with the local authorities. So that's very much dependent on the goods that are being supplied and crossing the border. And obviously with that then comes intragroup supply agreements, potentially distribution arrangements. So putting in place the intragroup contracts that then govern how those relationships work. And a lot of that's then driven by tax as well, so the tax implications of it. And I guess, you know, going forward, we're likely to see that continue, particularly as EU and UK law start to diverge. That's going to become more and more prominent, I think. I guess the other thing just to touch on in terms of why this is the case is services as well. So not much has really happened around services. The TCA didn't really deal with it much. And so again, I think we're going to see a lot more. Well, to date, I think COVID has sort of dampened the effect that Brexit has had on services, because there isn't the free movement of people anyway around the EU at the moment. But as obviously we come out of COVID, I suspect we'll see a lot more effect on the services industry as a result. Now, it's very unclear as to how that's going to work or what the effect might be. It's very much service dependent. Some services, sort of legal services, for example, are quite localized anyway, because you need to be, you know, UK lawyers, English lawyers. You can't go and practice in Germany without requalifying, for example, things like that. So it may not have a huge effect. Other services, financial services, regulated services, it probably will be impacted quite more, much more heavily, and where there is a need to move people across the border. So there's a lot of stuff in the press around the music industry, for example, at the moment, and how difficult it is for them to continue providing services. And so really, I think that going forward, that'll be the things that we'll still need to watch out for, I think.
Thanks, James. And I think those are really useful, very practical, helpful points to look out for in terms of the kind of the commercial side of things, I suppose. I'm just going to take it back to the purely legal side of life, if I may, for a moment. Kami, what do you think, or perhaps what do you know, might be coming down the tracks in IP?
So my main recommendation is to keep an eye out for changes to the law around parallel trade and exhaustion. I appreciate most people may not have heard of either of those things, so I'm going to break it down and just explain what I mean by that. So parallel trade occurs where goods are imported and exported outside of an IP right holder's normal course of trade, so when they first put goods on the market. And once a business first puts their goods on the market, they cannot then use their IP rights to prevent any further resale of those goods. So we say that their IP rights have been exhausted, and then this creates a market in second-hand goods. So, for example, Nike will sell trainers through their stores or online, and I could purchase those trainers and then sell them on eBay or, you know, a car boot sale, and Nike cannot prevent the sale of those trainers on the ground of trademark infringement because their rights have been exhausted. So moving on to kind of look at what that means for Brexit, I think prior to Brexit, Europe and the UK shared an exhaustion regime. So before Brexit, placing goods on the market in Europe, including the UK, exhausted the owner's rights to prevent resale anywhere else in Europe, also including the UK. And post-Brexit, the UK has maintained this position. But the EU has excluded the UK from its exhaustion regime and now treats the UK like any other third-party state like the US or Canada. So if the owner of intellectual property rights in Europe is different to the owner of intellectual property rights in the UK, the owner of the EU rights can block the import of genuine goods into Europe based on their intellectual property rights. So it's no longer lawful to parallel import goods from the UK into Europe without the consent of the rights holder. And those seeking to put goods on the market in the UK before exporting them to Europe will need the consent of the right holder before doing that. And practically, I think this is going to mean that people need to review any customs procedures that they have in place, and to make sure trademarks are registered with border control, etc. And the reason I say to keep an eye on this is because politically, the current position is contrary to the motivation for Brexit. You know, it's affording EU brand owners greater protection than for UK brand owners. And so the asymmetry of the position can't really be maintained. There's currently an ongoing government consultation about this issue. So I do suspect it's going to change, but it is obviously very complicated and rolls into a lot of the trade agreement stuff that James S. has been talking about as well. So I just think it's something for people to keep an eye on in coming months, really, and just to bear in mind.
Thanks, Kami. I think that's really helpful. Alex, data protection, again, seems to me that's always a hot topic. And I can't imagine that's going to change anytime soon. But is there anything in particular that's Brexit related, or perhaps even not Brexit related, that you'd recommend people look out for in the months and perhaps years to come?
Yes, well, the most important thing is definitely the adequacy decision. The other development that the data protection world is closely monitoring is the introduction of the new standard contractual clauses for international transfer of data, or model clauses as they're sometimes called. We actually got given a question from the attendees about the subject. Now, these are in the process of being finalized by the European Commission. They produced a draft version back in November last year. Now, just to clarify, these new clauses are not specifically a Brexit thing in that they weren't caused by Brexit. They would have been introduced irrespective of Brexit, as the plans to update them were already in place. But now that the UK is out of the EU, the UK is technically free to publish its own standard contractual clauses for international transfer. Indeed, I recently saw on ICO's social media post that the ICO is working on bespoke UK standard contractual clauses and intend to go to consultation on them in the summer. I personally can't imagine that this UK version will be greatly different from the new draft EU SECs, but we'll just have to wait and see. The ICO said they'll provide more information about their subject as things develop and give organizations plenty of notice and a grace period to adopt the new clauses as and when they become available.
Thanks, Alex. So finishing where we started then, James S., I'm going to come back to you, and I'm going to, again, hazard a guess that there'll be a fair bit that people need to look out for that might be coming down the tracks from your perspective, as this is such a continually evolving area. What are the kind of things that you would recommend people are kind of on the watch for?
Yes, so as you mentioned, it's a widely evolving area. It's sometimes changes are happening very quickly, and so it's never been more important for businesses to keep an eye out for any developments that may affect their sector. But that being said, one area which I thought is useful for businesses to keep in mind and to have it sort of at the back of their mind is that Brexit has resulted in a change to the UK's sanctions and export controls provisions. So just in brief summary to those in the audience who aren't familiar with this area, sanctions, broadly speaking, are measures which are put in place by government to target foreign countries, companies, organisations, as well as individuals to pursue the government's foreign policy objectives. And they encompass a wide variety of measures. It can include embargoes or restrictions on certain goods and trade in certain goods and technology. And it can also restrict or limit financial actions of sanctioned entities. And it's actually, we find, quite broader than you'd think. So certain products that you wouldn't think would ordinarily come under these regimes can actually end up being caught if you're not careful. So the pre-Brexit situation, obviously the UK implemented the EU's sanctions policy, and that has now ceased to apply post-Brexit. In its place, the UK has adopted what's called the Sanctions and Money Laundering Act 2018, and essentially that allows the UK to adopt its own sanctions regime through domestic legislation. For the time being, the UK has broadly adopted regulations that achieve the same effect as those that apply under the applicable equivalent EU legislation, and it's also expressed an intention to cooperate with the EU in terms of its sanctions policy. But what we're advising clients on at the moment is to not assume that the UK has simply copied and pasted the EU's regime. So, for example, the UK regulations are often consolidated versions of the EU's provisions, and they may be changed in certain aspects. The individuals which are targeted by the UK's sanctions regime have already differed from those under the EU's. And also, if you're dealing with exports of certain controlled goods, then if you had a license to do so issued by either the EU or the UK pre-Brexit, that's no longer valid for exporting your goods. So that's a lot of changes that have happened, but also the UK is now putting in its own regime. So in July of 2020, it put in place the human rights sanctions regulations. And just last month, it's adopted its anti-corruption sanctions regulations. And these provisions allow the UK to impose asset freezes and travel bans on individuals who've committed human rights violations on behalf of their state or engaged in serious corruption. So the UK is already showing its desire to push forward and develop its own autonomous sanctions regime, and seem to be quite a tough player on the global stage. And this is particularly relevant for people because the penalties for breaching these regulations and export control provisions are severe. So, for example, breaches of an export restriction can mean that you may face imprisonment of up to 10 years and or an unlimited fine. And that can be applied to both individuals and to companies as well. And that's also a step up from the previous EU regulations as well, the penalties in the EU regulations as well. And while historically the EU has been fairly reluctant to enforce its own sanctions regime, particularly if you compare it to the US, for example, there's certainly scope for the UK to increase its enforcement activities. So what all this means is that even if it's not something that happens if you're thinking about in your day-to-day activities, it's certainly important that businesses bear in mind that these provisions are there, and even more so if you're active in respect of high-risk jurisdictions or sensitive products or services. So we're really advising clients to familiarise themselves with the new UK regime, to not assume compliance on the basis of the EU's rules, and also to take proactive steps to ensure that their activities don't give rise to any risk of infringement. So implementing sanction screening policies, for example.
Okay, thanks, James. And I think we've sufficiently scared everyone there as a way to leave the main part of the panel. I'm conscious that's an awful lot of information, hopefully useful information, but an awful lot of information nonetheless for our attendees to take in. So I'm going to draw the panel discussion to a close in a minute so we can get into the Q&A. But before I do that, can I put each of you on the spot and ask for one short message that you'd like to leave our attendees with today? Kami, can I start with you?
Sure. I would say review your rights and check that they work for you. And if you're not sure if they do, come and see us.
That's always the motto. Come and see us. Alex?
For data protection, I would say your efforts to comply with GDPR when they came into force before Brexit have not gone to waste. They still apply. Brexit alone hasn't brought about an overnight change in the requirements. But data protection is a very dynamic area. So please keep your eyes open for further changes in this area.
Thanks, Alex. It's always good to hear that all of your hard work from 3 to 4 years ago hasn't gone completely to waste. James H., what would you say?
Thanks, Joe. I'd probably just say, similarly to Alex, just keep an eye out for things that are coming down the track. I think it's interesting, for example, I think it was yesterday or the day before, there was no employment bill in the Queen's speech. And one of the other things I'd probably mention is the fact that there was promised a consultation on workers' rights post-Brexit, which was cancelled pretty soon after it was announced. So don't be surprised if that gets re-announced, I think that's the right term, in the near future. So yeah, just keep an eye out, basically, is the top message from me.
Thank you. James S., what would you say?
Yeah, so from a sort of international trade perspective, I would just recommend check and double check the current arrangements that apply when clearing your goods through customs, because if you get it wrong, it can cause delays, it can disrupt your supply chains, and potentially cause issues with your customers and suppliers. And in some circumstances, you may end up paying additional duties or incurring further costs when you otherwise wouldn't need to.
Yeah, nobody wants that, do they? And finally, James B, what's your one takeaway message for our audience today?
So I think in terms of commercial contracts, whilst not a huge amount has changed in how we are going to draft, how we are drafting contracts, I guess the key takeaway is that, particularly where you're dealing with international cross-border contracts, just to really think through the provisions that you've got in that contract in a little bit more detail. Does it still work? Does it allocate risk and address and mitigate risk that has come about because of Brexit commercially? So whether that's Incoterms, dealing with delays, the movement of people, that's really the key message that I think when dealing with international contracts, you just need to give the contract detail a little bit more thought.
Okay, thank you very much. And on that note, I'd like to open the floor to the Q&As. We've had a few questions in actually. First question, which our audience member says might be for all the Jameses. What policies or regulations might businesses need to consider, particularly post-Brexit, for any increased demand for remote cross-border employment? And also a simpler question, will the recording for today be shared? I'm going to take the simpler question and say, yes, it will. And then I'm going to hand over to my colleagues.
Thanks, Joe. Well, I can offer some initial high-level thoughts on that. I think we might have seen, during the pandemic, countries such as Barbados were advertising, saying, come and work from home in Barbados or something. I think I may have seen that. So that sounded tempting. But I think the key things to be thinking about here in terms of remote working, it's not really, I don't think there's any kind of Brexit impact to be thinking about, but correct me if I'm wrong, the other Jameses, but it's more about thinking about the tax aspect of somebody who's working in another country, but and things like that. So we'd be happy to look and offer some proper, more detailed advice on this if helpful. And the other thing I would note is if somebody's working and is effectively domiciled in another jurisdiction, and they have employment issues that they want to raise, such as unfair treatment and things like that, they will do that in the place where they are based, if that makes sense. So we deal with a lot of UK employees who work, one or two people who might work for a US company, and they're the only two individuals in the UK, so they would bring their claim here. So the same would apply in other countries.
Yeah, I mean, I guess that's quite a wide question really, and it's very dependent on the contract and the industry sector you're working in. So regulations will be whatever's relevant to your goods or services, whether that's as I mentioned before, whether that's sort of packaging, labeling requirements because they're now different because we're not part of the EU, or vice versa, then supplying goods into the UK. So it's really just being on top of what is it we're supplying, what are the goods and services, and what's the now current regulatory regime that applies to those goods and services.
I would just echo those comments. I think we're still at quite an early stage in working out exactly how these things work, and at the moment things are still very specific and limited to whatever area or type of service or the type of activity that you're providing. So it's a case of narrowing it down to what exactly you're undertaking.
Thanks everyone. Just looking through these questions. Kami, I've got one for you. What practical steps should we take to ensure we have the right rights in the right territory? I'm going to anticipate what Kami's going to say first. I'm going to say come and speak to us, but apart from that, what else would you say, Kami?
Yeah, of course, come and speak to us. But I think it's about, if you've got multiple registrations in different territories, if you are using an agent already, work with your agents that are managing those registrations and talk to them about what you're still using. I think there are lots of brands who preemptively register or lots of businesses who preemptively register brands and then never end up using them, or it doesn't quite take off in the way that they'd hoped, and it is expensive to maintain trademarks. So make sure that you're not paying for something that you're not using. In terms of making sure that you have somebody who can manage your registrations in the relevant territory. In Europe, you now need somebody who is based in Europe to manage and deal with any representation at the EU Intellectual Property Office. And similarly in the UK, it must be somebody based in the UK to deal with the UK IPO as well. So it's about just making sure you've got the right contacts, the right people to talk to about it, and then sitting down and taking the time to look at what you are using as a brand and what you're not using and what you have registered, and then also really analysing the goods and services that you've got it registered for. I know that some businesses preemptively register really broad marks covering loads of different goods and services, but there have been some rules and some case law around whether doing so when you know there isn't a real possibility of genuine use in relation to those goods and services can actually invalidate your mark. So it's just thinking a bit more cleverly about the registrations that you make and taking the time to work through them, really.
Thanks, Kami. Alex, I've got a question for you. Are you able to touch on international transfers from the UK to the US in light of the Privacy Shield invalidation? Do you think the SCCs are enough protection for these transfers to the US? And do you think the ICO will approve the new set of SCCs?
Right, so the latter part of that question I covered in my earlier response when we were covering things to look out for. Well, the subject of Privacy Shield invalidation Schrems 2 is a rather complicated one, and I think we're still waiting for the definitive position or guidelines from the regulators in terms of what needs to be done on this. Unfortunately, it's one of those case-by-case scenarios where it really depends on the personal data that's intended to be shared. I think at a high level, we would say carry out a risk assessment, identify what data is actually being transferred. Is there a need to transfer that? Is there a way to not transfer that, anonymizing it? And then what are the chances of, or has there been precedence of that data being intercepted or being requested by intelligence agencies, etc. And then, yes, use the SCCs, but consider putting in more provisions, more protection for the data that's being transferred. Because with the SCCs, you can't take out stuff, but you can certainly add more provisions in.
Thanks, Alex, and I hope that helps to answer that question. So we've got another one. In terms of forum for contractual disputes, is the recommendation to opt for exclusive jurisdiction of the English courts to ensure disputes are heard in the UK rather than non-exclusive? James B, I'm going to give a little bit of my answer on that from a ComLit point of view, and then maybe if you want to supplement it. I would say certainly opt for exclusive jurisdiction if at all possible. It makes life an awful lot easier once you get into the realms of a dispute. That is, of course, if you want it to be heard in the English courts. If you don't want it to be heard in the English courts, we need to be looking at something like an arbitration or something else, another jurisdiction clause. But generally, yes, go for exclusive, I would say, and clearly depending on your contract, go for exclusive jurisdiction rather than non-exclusive.
Yeah, I think, Joe, I'd echo that. So I mean, in reality, I don't think it's really changed necessarily our advice on how we deal with jurisdiction clauses. The basic position is you'd probably want to choose exclusive jurisdiction of the English courts anyway, even pre-Brexit. I guess what it's done is meant that because we're no longer part of the EU, whereas in international contracts outside of the EU, we would be going, you probably want to think about arbitration rather than jurisdiction, court hearing the dispute. I guess what it's doing is pushing us towards potentially choosing arbitration for EU contracts, not just sort of global contracts. But yeah, it definitely exclusive over non-exclusive, and question whether you should probably be going for arbitration.
Yeah, it's all sorts of things to consider. There's one for you, James S. Apart from paying customs duties, are there any other issues my business might face in placing our products on the market in the EU or the UK?
Yes. So some of the areas that we're seeing getting increasing activity is sort of non-tariff regulatory barriers to trade, and that's part of navigating the sort of EU regulations and how they diverge from UK regulations. So one of the areas we've seen this coming up is that obviously the UK no longer being part of the EU, it's treated as a third country for purposes of EU regulations, and this means that certain EU regulations, I think Machinery Directive, for example, various other ones, regulations such as these, which have specific activities which manufacturers have to undertake, or authorized representatives of manufacturers have to undertake. And some of these required that there is a EU presence, and some of these activities are carried out in the EU in order to ensure that products meet the specified product safety requirements. So I think practically that may pose a barrier to some UK businesses, and it gives rise to the need to sort of double check the regulatory the provisions that apply to their products, and to ensure that they can continue to carry out the functions that are necessary when trading with the EU, or otherwise investigate how to modify their supply chain. And it's one of the things that James B has talked about earlier on. There's also a change in terms of the CE marking and the provisions that apply to certain products. So UK has replaced the EU CE mark, which confirms that a product complies with relevant product and safety requirements, and it's replaced it with its own UK mark, the UKCA, and you're able to put both the CE mark and the UKCA on your products up until I think it's the 1st of January 2022 at the moment, but that is currently subject to the standards for product conformity and assessment remaining the same between the UK and the EU. It's something that we sort of touched upon earlier, whereby there's a potential for the standards of the EU and the standards of the UK to diverge. So compliance with one standard might mean that a product is not compliant with the UK's standards or the EU standards. So again, it's something for businesses which require CE marking or product safety labeling for their products to keep an eye out for and keep looking out for as in case these things do change.
Okay, thanks, James. James B, I've got a question for you. That's an interesting one. Are references to EU legislation in commercial contracts now wrong?
Good question. So I think the answer to that is no, not necessarily. So I think from a commercial contracting perspective, you can agree whatever you want to agree in the contract under English law. So and it's quite common in international contracts, for example, to have references to local insolvency legislation, for example, if to determine whether an entity is insolvent under their own legislation. So having a reference to EU law in your contract is not necessarily wrong. It obviously just may not make much sense if it's a UK domestic contract. But it may, of course, be perfectly sensible to have that EU reference if it's cross-border. So an obvious example would be TUPE, for example, where in the UK, if it's a UK contract, you'd probably want to talk about TUPE, whereas if it's in the EU cross-border, it might be you want to be talking about the Acquired Rights Directive. So I think it very much depends on context. And again, it's back to that point of really when you're going through your commercial contracts, just giving it a bit more thought as to whether that is actually the appropriate reference that you should be having in your contract.
Thanks. So not a blanket no, which is or yes, as the case may be, which is always nice
Correct.
to hear, I think.
It depends, typical lawyer
It
answer.
depends, yeah, sorry, we do like to give that answer. So I think I've got time for probably one more. It's probably quite a good one to end on, actually, because it's quite general, I think. So anyone who's got any thoughts, please jump in. What do you think is the most significant legal change that has been or could be made post-Brexit? I'm going to start by saying, from my perspective, as a litigator, would be enforcement of judgments in the EU and probably also service of proceedings. Not quite as straightforward as it used to be, but I'm going to throw that open to the panel. Does anyone have any particular thoughts on that?
Well, I'm happy to just jump in and repeat maybe a little bit of what I said earlier, but I think potential changes to TUPE, I mean, I know James B's just talked about it as well, but that could be huge, because as things currently stand, you know, after a TUPE transfer, if you want to harmonise employees' terms and conditions, you can have some really real issues with that, because you might effectively need to be dismissing employees and re-engaging them, and that could be void as a result of the transfer, and all sorts of issues like that. So if that is removed in the future, it would certainly be, I think, a really positive change that Brexit's, you know, effectively facilitated.
Okay, thanks, James.
Just to add to that, I think GDPR was in itself a very significant legal change for everyone. So I don't think anything of that magnitude is in the works anytime soon. But as I mentioned earlier, data protection is a pretty dynamic area. So I think we all need to be on the lookout for certain developments within the framework of GDPR going forward.
I think that'll be welcome, Alex, because I can't imagine anyone fancies going through GDPR Mark II 5 years later. So I think that'll be welcome news.
And I think I mean, I think that's just generally the main point here, is that actually it's at the moment we've retained a lot of the EU law. So really a lot of this is going to be about waiting and watching and seeing what happens going forward as we start to the regulations and the law starts to diverge. So it's a little bit of an unknown, I think, at the moment.
Kami, did you want to say something? Or?
Yeah, I was just going to second what James B's just said and say it's all about where we start to move away from EU law. So in terms of IP, a lot of our case law is very heavily influenced by EU court decisions, and that's because the rights have been quite heavily intertwined and they're all very similar. So the legislation itself can be similar, but I think, you know, the IP is designed to adapt to new technologies, and as new technologies start to be created, and as maybe the UK starts to take a lead in certain areas, it might need to start developing different case law and different regimes to protect those rights. And so it's not necessarily going to be immediate, but it's certainly something that we could see happening in the future. I think it's just keeping an eye out for it, really.
I think I just make one point that sort of bounces off what Kami says there, is that obviously the UK has retained a lot of the, as we've said, the EU's law, and that is workable from an EU context. And I think what we're going to see in the future is that certainly a lot of the UK domestic legislation and regulatory provisions that apply in respect to products may have to actually change, because in order to reflect the realities of the UK market. So I think, you know, we're still in the early days and seeing how all of these provisions are transposed now into a you know, domestic UK legislation. But it's a watch this space scenario again.
Thanks. And we are coming up for 12 on the dot now. So I think that's a good place and a good message to leave it on. So thank you very much for coming. And thank you very much for all your questions. I'm aware that there are a couple of questions that we didn't manage to get to, but we'll pick those up offline, so to speak. So yeah, that's all, and thanks very much.